So a major change in a plan late in life can be problematic.
Welcome to Alt Investing Made Easy, where we explore the complex world of alternative assets. I'm Roland, a securities attorney, investment advisor, and your co-host.
And I'm Sarah, an investment advisor and corporate attorney, and your other co-host. We'll guide you through real estate, private equity, and more, making complex topics accessible.
Tune in for insights that empower your financial journey.
Let's make alt investing easy, one episode at a time.
Welcome, everyone, to Alt Investing Made Easy. Thank you for joining us today. Today, we're really excited to bring to you a conversation with our colleague, Mr. Eric Bean, attorney at FBFK Law, and his specialty is estates and estate planning. So we're excited to hear about this topic today. Thanks for joining us, Eric.
Thanks for having me.
Yeah, it's great to have you here, Eric, and thanks for being with us. Why don't you tell us about your law practice, Eric?
So our practice, and I joined FBFK from a small firm that had been around for about 30 years, and our focus was primarily on estate planning, but also estate administrations and litigation. And so, we kind of approach planning with an eye towards avoiding litigation, avoiding guardianships, and that's pretty much what we do: estate planning and administrations and litigation.
Yeah, and maybe as a quick follow-up, just for our audience to understand, why might an estate planning attorney get involved in litigation?
Oh, any number of reasons.
At the heart of it, it's a dispute regarding the estate, right?
Yeah. So, the handwritten will on a napkin is a good example. I read a couple of recent opinions about that very thing. What does the handwritten will say or mean? And who are the beneficiaries?
It's funny because I think, Eric, just thinking about it, it probably makes sense to a lot of people that it's, families fight over money when the person who has the money is gone. So, for everyone watching, that means litigation, right? In the legal context is, when families, get mad enough, then they litigate. And I think, Eric, the napkin is one kind of conversation, but there's other kinds of fights that people have too that, I think that you probably have been involved in.
Yes. So problems arise with last minute changes to a will when somebody is elderly. The classic example is a child calls the lawyer and says, "Mom needs to change her will." And who is driving that ship? And are the other potential beneficiaries going to contest the will and say, well, my sibling was actually controlling this, and that's why my sibling is the only beneficiary? When the prior wills treated us all equally. So a major change in a plan late in life can be problematic. Another one that we have seen recently is if a will creates trusts, or if there's trust planning involved, putting a sibling, naming a sibling as a trustee over other siblings might not be the best idea.
I can see how that would make sense.
Yeah, everybody says that everybody gets along until they don't.
Yeah.
And then you have problems. So there's a myriad of issues that can cause litigation.
Well, Roland, were you about to say something?
No, go ahead.
Go ahead. Oh, well, Eric, we had talked before that today we were going to talk a bit about something that's going to be of interest to the audience that we seek to address here on this podcast. And that is, if you're an accredited investor, then you have $1 million of net worth that's in excess of your primary residence. So you probably should do some estate planning and would want to, and perhaps you have assets that are more significant than that. But now we have a new limit, which is the $15 million. And could you talk us through some sort of estate planning considerations for people that have assets that need to be taken care of, but also, don't surpass the $15 million cap, which is a whole different thing, kind of estate planning that you get into, I think, once you exceed the exemption.
Well, and that really depends on the client and the client's needs. Even with, if you're approaching that amount, you can use some of the techniques, trust planning within the will, to just ensure that at least some of the exemption is sequestered away from the taxation. There is still the marital deduction, family trusts or bypass planning, or even disclaimer planning, where there's just the potential for a disclaimer trust in order to sequester assets that might be subject to the tax.
So just to maybe recap, this has been in flux a little bit, but the law basically says, from kind of the simplified form, that if you have an estate that's less than $15 million, and at your death, it'll transfer to your beneficiaries. You won't pay any tax on that. Is that a good summary, Eric?
I mean, that's the basic gist. Yeah, that would be what we call a non-taxable estate.
And that's where you focus primarily your practice on.
That is. So when I joined our prior firm, the partners of that firm had made a decision long before I joined to focus on non-taxable estate planning. Just because of the complexities and the tax implications of that. And so they wanted to focus on the smaller estates and not the legacy planning. So we really, and colloquially, we refer to it as leave it to Beaver planning. That's what another law partner likes to call it when we're just chatting with folks. Is the classic example for me is my wife and my kids. I mean, it's just, I leave everything to my wife, she leaves everything to me. If we both die at the same time, it goes to our kids, probably in a trust. And I mean, it's very, very simple generally. And I mean, there are ways to add, complexity, or uh, help the client achieve his or her goals, but it does not entail what I call the acronym soup of trusts or family partnerships or these other techniques for avoiding the tax man.
What got you interested in estate planning and the associated litigation practice that goes with that?
that Roland, is a function of choices. I was practicing at a small law firm and it wasn't a good fit. And a colleague that I had worked with said, "Hey, I know this guy that's hiring at his firm. If you're interested in a move, call him up." We interviewed. I was told, "Hey, this is what we do. We're a kind of a boutique estate planning and probate litigation firm. Um, you know, if you'd like to join us, come on." And so that's really how I got into it. I took wills and trusts in law school, thought it was interesting, didn't really understand it at the time, but over the course of the last about 10 years, I've come to enjoy the practice. It's a niche practice, and at least in the Houston area, there's not a lot of people that do the estate litigation, fiduciary litigation, and the estate planning. So it's kind of something I happened into when I was looking for a new opportunity.
So now I want to ask you the question, because it's interesting that it's so niche, because actually, everybody needs to do some estate planning. So I looked at your presentation, and I think this would be interesting to just lay out a very simple framework, and it feeds into what the Leave It to Beaver planning is. What is the alternative to not estate planning?
Well, and this so when you refer to the presentation, I give occasionally presentations to community centers here in Houston, what I call estate planning 101. And one of the first questions I ask, or that we get asked as estate planning attorneys, is, do I even need an estate plan? And the response, classic lawyer response, is you already have one.
Hmm.
The legislature has written one for you. And the question is, do you like the legislature's version, or would you rather have a little bit more control over how your assets will pass? And
Yeah.
I think that kind of changes the focus of the conversation. Is, the people, your beneficiaries have been decided. Are those the people that you want to receive your assets on your death?
Hmm. And
And
it's
even
probably
if they,
important to note. Oh, sorry. Go ahead, Roland.
no, I was just gonna, if even if they are the same people that it still does a benefit to your beneficiaries to go ahead and prepare a will, right? I mean, it simplifies things a little bit. Would you say that that's accurate?
Uh, I would say, yeah. I mean, it's very accurate. The process when you don't have one versus the process when you have a properly drafted, properly executed will is a big money savings on the back end for your family.
Hmm.
You invest a little bit today, and especially in Texas, probate is very simple. You probate the will, there's a short hearing, you're appointed independent executor, and that's pretty much your entire involvement with the court, other than filing an inventory of the estate. But then you just follow what the will says, and you never have to show up in court again.
Oh,
On
wow.
the other hand, if you have an heirship, you have an application, you might have litigation related to who is going to be the administrator of the estate. If not everybody is getting along, then the court will appoint an attorney ad litem. And so you're paying not only your attorney, you're paying another attorney, a court appointed attorney, and you have those same fees. And then depending on the type of administration, you might have to go to the court for everything that you do. If you want to sell mom's house, you have to ask for permission. If you want to pay your attorney, you have to ask the court for permission. And so it becomes a real burden on your family after you die if you have not done some measure of planning.
Yeah, I think that's something that can't be overemphasized. And of course, we could get into it, but if you have minor children, it's even more complicated, isn't it? If you haven't gone ahead and identified who you want your guardianship arrangements.
Yeah, it's a real problem because minors can't inherit.
Yeah.
They can't take possession of these assets. They can't sign contracts. And so somebody has to do that. So if there is not, and that's another aspect of that, that's not in your will.
Hmm.
We usually have a separate document that declares who the guardians of your children are going to be.
Hmm.
So your will might provide for a contingent trust for the minor children if there are minors, but you have to have somebody, if both parents die at the same time, God forbid,
Hmm.
um, somebody has to step in as their guardian, and you can declare before this happens who that should be. And so when the guardianship proceeding does inevitably happen, that decision has already been made, and it makes the process much easier.
So that's a separate document from the will, is like a declaration of guardian, or?
Yeah, it's there's a declaration of guardian, and then even for adults, we've had cases involving an adult who was elderly. There might be a blended family situation. An adult can assign a declaration of guardian in case of need to make sure that the courts know if a guardianship is initiated, that a preference has already been chosen as to who should be the guardian.
Eric, I lived abroad for a long time, and it's interesting how these issues, when you're an expat, a long-term expat in a different country, these are really important issues because I think most countries for expats have a process by which you would go through a guardianship process and identify who you want to take care of your kids. But you also need a temporary guardian because if you're abroad, then you need something to happen while the person who's the permanent guardian, likely your family or someone from your home country, comes and takes the kids. So it's one of those things that nobody likes to think about, but you're going to lose sleep a little bit if you don't take care of it, right? So
Yeah, I mean, when I first joined our prior firm, the partner I was working with said, you need to get an estate plan. You can't be one of those lawyers that doesn't have one and then work at our firm. You got to get it done. And I will tell you, I mean, once we signed those documents and we had that in place, a lot of peace of mind followed up. I mean, because we know we've got the plan. Should we revisit it at some point? Yes. But
there's
right
something.
now there is something there that can function, and that is a huge relief.
Yeah.
Yeah, it's interesting how that can provide peace of mind to people. It's a struggle, though, right? I think maybe this is something that people resist because we all have such a deep fear of our own mortality.
Yeah, I mean and on the lawyer side, you develop kind of a callus to it, and it becomes gallows humor a little bit. But yeah, having the conversation is difficult.
Yeah.
Especially it gets very difficult because at some point, if it's spouses that are leaving their property to each other and then to their children, you have to ask the follow-up question: what happens if you all perish in the same event? Who's next?
Yeah.
And if they say, well, my siblings, then, well, okay. What happens when you are all on the same cruise together and it hits an iceberg? Who's next?
Yeah.
And you have
Yeah.
to go down the line until you get to the end.
Yeah.
I always bring up the Downton Abbey. I don't know how
I love
many
that
people
show.
think about Downton Abbey, but I think that everybody, they had no heirs other than this one cousin out there that just
Yeah.
happened to be still around. So those are the conversations you have to have. If a little gallows humor helps move that along, then maybe that's good. Maybe it's not. I don't know. But that's kind of how we do it. You gotta have the talk.
Yeah. Yeah.
Rip off the Band-Aid, so to speak, right?
Yeah.
Well, we were talking earlier about, I mean, I think it's so difficult to talk about death. And then people, depending on their religion, also have different ways and things they believe about all of that too. In my experience with people from different religions around the world, like different religions have different beliefs about how you're supposed to prepare for after death. And that can be pretty influential on people, obviously. But we, something we had mentioned before, Eric, which is so important too, is we're talking about death. And I just wanted to make one comment, and we've said this before, Roland, don't be penny wise and pound foolish. Like, spend some money on your estate planning. It will save money later, and you will buy yourself this peace of mind. But also, we had talked about planning for death. You said it. You have a phrase: planning for death is the simple part. It's the complicated part is planning for incapacity. You want to explain that a little bit? Or I think I said the phrase wrong.
Yeah, it's easy to plan for death. It's hard to plan for incapacity. You got it. You got the gist.
The gist of it, yeah. Why is that?
Well, I think part of it is a potential client calls and says, "Can you draw me up a will?" I mean, that's what everybody is thinking of is, can you just draft me a will, draft a will, go to LegalZoom and get a will, et cetera, et cetera. And so from the time I started in this practice area, we have always referred to what we do as an estate plan. It's a holistic group of core documents, and then there are other documents you can add on as you prefer, but certain core documents that not only, the will plans is the death document, but there are, and our primary documents are the financial or the statutory durable power of attorney, the medical power of attorney, what we call a directive to physicians, and then we also do a HIPAA release. And what a lot of these documents are designed for is if you are in a situation where you cannot make a decision, somebody has to step in to make decisions for you, whether it be accessing bank accounts, selling real estate, or, making financial decisions. Or if you're in a car accident and, again, here's the gallows humor again, the doctor says we have to take the leg, but you are unconscious. Somebody has to make that decision, and the legislature has already made that decision. And so the documents can override the legislature's defaults. Maybe you don't want your, spouse to have to be in that position, so you feel more comfortable having somebody else make that decision. Or maybe your spouse said, "I don't want to make that decision." And so but if you make the decision now while you can, it makes things easier when you can't. The same thing, for the directive to physicians, which is essentially end of life decision making. Again, the legislature has made the decision as to who decides whether to deny, life-saving treatment if you are diagnosed with a terminal or irreversible condition. But you can have signed a document where you have made that decision before anything has happened. And so when the time comes to tell the doctors what needs to be done, somebody just has to pull that document out of your folder and say, "Here's this person's decision." Even though he or she cannot speak, they've made the decision. And that there is a comfort in that, because you're not putting it on somebody else.
Yeah. I think it's really important because I do think when you get an estate plan from a, good lawyer, the will is there, there are trust considerations to go through, but there are all these other documents. And that's exactly what you're talking about. There are the medical powers of attorney, the powers of attorney, the advanced directives or living will documents, HIPAA release. And I think from the point of view of a client, it could get a little overwhelming. But it really helps, I think, the way you've described it, Eric, to think of it as the document that is the death document, for want of a better way of describing it, and the other documents that address incapacity. To really put it into those two categories, I think can kind of probably help people focus their minds a little bit in terms of not getting overwhelmed by the process. Because again, depending on the individual, I would imagine that some people are super with it and ready for this, and maybe were raised in an environment where they talked about family wealth, or not even family wealth, but family assets that were already owned in a family context. Or, some families are more exposed to the fact that this is a will, you were in your grandmother's will, this is what you need to do. It makes more sense. And other people haven't had that and need to kind of go through that process. So I imagine it's really interesting from the point of view of being the estate planning attorney, especially since you do the litigation and you see when it all breaks down. How you really have this bird's eye view, don't you, of both sides?
It helps to provide real world examples of what happens when these things are not done.
Yeah.
And one of the big ones is, just kind of segueing this incapacity issue is, and you mentioned it, or I mean, we kind of chatted about it with respect to minors, but guardianships.
Mm.
So in Texas, there's you can start a guardian or initiate a guardianship proceeding, but the court has to consider whether there are alternatives to guardianship that are feasible that would avoid the need for the appointment of a guardian. And many of these alternatives are financial durable power of attorney, medical power of attorney.
Mm.
All these ancillary documents not only allow you to make a decision before an event occurs, but they are statutory ways to avoid a guardianship.
Mm.
And I can tell you from experience, you generally want to avoid guardianships.
Mm.
Because you're getting the courts and other people involved in your caretaking that you might not want them to be involved.
Yeah.
And guardianships are, and I could go on, but are, a legal means without a criminal conviction to take away rights.
Mm-hmm.
And if you can possibly avoid that, you want to do it.
There's that famous. Sorry, go ahead, Roland.
Yeah, well, so no, you make the point. The famous.
Your point is probably more substantive, but I was just going to say a famous example of a guardianship was Britney Spears, right? And there was a big battle over whether that should or shouldn't continue. And I always thought, well, whatever her issues are, she is an adult, right? So
yeah. It's a really difficult thing to deal with. I mean, and I mean, just a story, in my presentation, I have examples of, does this person need a guardianship or not? And one of them is, you could be looking at, I could be looking at my parents who are, going on vacations or giving away money. And I could say, well, they're acting irresponsibly, and call a lawyer and say, hey, my parents are just spending money like crazy and et cetera, et cetera. But then, if you take the time to talk to the parents, they say, look, it's my money.
yeah,
I will spend it how I please. If you think that's foolish, that's fine.
Yeah.
But it's not your money.
You don't have the rights to that. May want it.
So sometimes it's used as a way to control somebody, and so it's something you don't want to get embroiled in if you can avoid it, in my view.
So in that scenario, and this is probably why, what happened with Britney Spears, not knowing the specifics of that, but you have to show an incapacity, like your parents spending money irresponsibly, and from your perspective, that's not actionable. But what's actionable is that if you can demonstrate that there's some kind of incapacity there, right? Isn't that the issue, or what you would have to show?
it's, I mean, without pulling out the state's code and reading it to you, it's an inability to take care of yourself, to take care of your finances, whether due to physical or mental deficiencies, an inability to handle your finances, to take care of your activities of daily living, bathing, eating, paying your bills, etc. I mean, the classic cases is dementia or diminished mental capacity, but there's also physical incapacity as well that just renders somebody unable to handle these things on a daily basis.
Mm. You know, uh, long time ago, actually, before I became an attorney, I worked for a social service agency. It was in New Mexico, and we were appointed what's called guardian and conservators, which the conservator is the financial piece under New Mexican law. And so I worked in that section, managing money and managing assets for people that had been determined to be wards of the court. And it was very, very fascinating. I was very young, and it was like my first job after getting my MBA. And it was really, really, really interesting because of all of these issues that come up every day. There's a question mark, like, is this the right thing we should be doing for this person? But typically the scenario is with adults who've unfortunately been abused by their families, who don't have somebody to rely on besides an independent party. And so it's a really fascinating kind of area to work in. It's very rewarding, not necessarily lucrative, but really important work that people do. And the medical decision making, which is the part that a friend of mine worked in, it was incredible the amount of knowledge that she accumulated over time, taking care of making medical decisions for people that were overseen by the court. It's a
Right.
whole area of life that hopefully you don't have to learn about, but there's some very serious and experienced professionals who work in that space, taking care of people who need help, essentially.
Yes, and I will just temper my passion a little bit. I would say, because I've acted as an attorney ad litem on
Mm-hmm.
guardianships, and the bulk of them are legitimate. I would say a
Yeah.
vast majority are incapacitated children turning 18, and
Mm-hmm.
somebody clearly needs to take care of them.
Yeah.
A truly incapacitated adult who's just having problems, and the children need to do something to intervene.
Mm.
Many of them are l- legitimate.
Yeah.
It is a good process and generally functions.
Yeah. I think
It's
it's a really
when
important thing our courts do, actually,
it
that
is
to
a
help our
very
society as a
important
whole.
function.
Yeah.
Absolutely. It's when it breaks down and
Mm.
somebody tries to use the system
Mm.
to their own ends is
Yeah.
when problems really start to arise.
Of course. Well, I would say that's kind of a segue into, what we tend to get into towards the end of our interviews, Eric, and that is, you know, what personally motivates you in this area? Like, it sounds like I could tell when you started talking about the guardian ad litem. I mean, obviously, just for the record, it's not probably the most lucrative thing, but it's one of those things when you're an attorney, especially the skill set that you have when you get to use it or deploy it in the service of people who, for whatever reasons, need extra support. It's quite rewarding. So but perhaps there are other things. I know other things about you, like the fact that you're an extremely highly trained musician and a very good performer, because I've witnessed that.
Well,
um,
I mean, the easy answer is what gets me up is my family,
yeah,
um, and my kids. But just helping people navigate this process. Um, I mean, litigation can be its own creature. Um, and hopefully, I mean, one of the things I again, it's the gallows humor, but sometimes, litigation arises. You're trying to help clients navigate that. but reminding the parties sometimes that, well, y'all didn't cause this problem.
Mm.
You know, a lot of these problems are caused by not doing the planning.
Mm.
And so don't blame the people that are involved in this fight necessarily.
Mm-hmm.
It's not necessarily their fault. Yes, you're fighting, but it's because there was something went wrong earlier that
Yeah.
could have been avoided. And then also, it's not your money that you're fighting about. It's found money a lot of times. And so whether that helps get somebody there, I don't know, but it's a reminder that, we're talking about somebody else's earnings, somebody else's legacy. So helping people navigate kind of that thought process. And then, yeah, when a family comes in and they say, we don't have any planning, and they leave with a plan in place, you can see the peace of mind when, and from the guardianship perspective, one recent one, I was an attorney at litem and appointed to represent a proposed ward who was a minor that had just turned 18. She was completely incapacitated, nonverbal, um, basically confined to her bed. But her grandmother was taking care of her. The family situation was not great. And I went out to grandma's apartment, and it was, I mean, just the to see how passionately this grandmother raised this child from childhood all the way through this point, and was doing, I mean, she was gonna graduate from some educational program, and grandma was making her an outfit with shoes with glitter and all sort. And I mean, those kinds of things, when you can help a family get that process done so that they can make medical decisions for this young woman and continue to take care of this person for the rest of her life. I mean, it's very rewarding when you see those kinds of things come to fruition.
Yeah.
Yeah, I mean, people's helping them meet their fundamental needs at that really basic level. You remember being an attorney is really a noble profession. We really can be in a helping role.
Yeah.
Yep. And sometimes we need to be reminded of that.
Yeah. It's easy to get cynical, But that said, not to sound cynical, and especially because we're winding up, I do want to reemphasize, two certainties we know are death and taxes, right? And incidentally, that's exactly what you need an estate and tax planning attorney for. Perhaps we've been talking about the version of the estate planning that doesn't have to consider taxation so much because of the large exemption available now. But definitely, it's interesting that your practice area essentially covers one of the main certainties in life.
Absolutely.
And therefore, it's very important.
I think so.
Yeah. I think everybody needs to think so, in my opinion. So, but anyway, Roland, do you have anything else you want to address?
No, I think that's great, Eric. Thanks so much for being with us and addressing something that's difficult for people to think about maybe or plan for, but necessary for sure. We hope that we've shown that.
Yeah.
Well, thank you all for having me, and it was great seeing y'all in Austin, and hopefully I'll get out there again soon.
All right, everyone, thanks for joining us today on Alt Investing Made Easy. We hope you found this episode interesting and useful, and please like and subscribe to our channel.
Everyone take aim with your alternative investing strategies.